Um, since we have judge shopping in one state, do you suppose that maybe Judge Moody got shopped in Arkansas? Like, is that just a possibility in your mind? You might not have any evidence to suggest that, other than a gut feeling. Just a gut feeling. What do you think?
I would never, ever speculate without evidence, without a firm report signed by three judges, that a certain group of lawyers is going around judge shopping in the South. So I just cannot make any speculation whatsoever about how those lawyers who were the same people in Arkansas a year earlier ended up with a super favorable judge. I just can't say.
I am talking to Unyielding Bicyclist, who is the author behind the Bad Facts Substack. Does terrific work. I have reposted her work before because it's terrific. And we are here to talk today about a couple of the court decisions that have taken place that are working their way up from the states that have passed bans on pediatric transition. Because there are all kinds of shenanigans and things going on. Without further ado, introduce yourself to our audience, Unyielding.
Thanks, Matt. So my name is not Unyielding Bicyclist, but I use that on Substack. And I've been writing about trans issues on that platform for about a year now in one place or another. I'm especially focused on the law because I am a lawyer. And so that's what got me into these lawsuits we'll talk about today in Arkansas and Alabama.
So we're going to start in Arkansas because we're going to position this as good idea, bad idea. Let's go ahead and start with the bad ideas that took place in Arkansas. What is it actually that you found so compellingly wrong about Brandt?
Well, I found things wrong in terms of what the plaintiffs were doing, what the defense, the state was doing, and what the judge was doing. So this is a great case to start with because it's actually the first state in the United States that passed a ban on gender medicine for kids under the age of 18. And this was in 2021. The ACLU came and brought a lawsuit, immediately upon passage. So that's why this case was the first in the country to go to trial. The ACLU is teamed up with Sullivan and Cromwell, which is, one of the biggest law firms in the world. So huge guns they brought into Arkansas. And when I dug into this last summer, I was really surprised by a lot of things. So the way I saw this was, first I read about it in the media at the time. I probably read, the New York Times. Every outlet kind of covered it and just said, haha, the trans kids beat the evil state of Arkansas. And the judge, explained why science was on their side and Arkansas was not scientific, whatever. Very shallow coverage. You couldn't really tell what had happened. And that was in June of last year. And then, like maybe a month or so later, I realized that the transcripts from the trial were all online at the ACLU's website. This was an 8-day trial, like 1,000 pages of transcripts. You could read everything that people said when they were on the witness stand, from one of the kids themselves, the kids' parents, the expert witness doctors. It was all laid out there. So it was very exciting to find. I mean, and I could also find the opinion that the judge wrote and many of the briefs that were filed by the parties. So that's all available for the public to inspect if you have a weird amount of time on your hands, which apparently I did. And in terms of what was problematic, I mean, so the ACLU and Sullivan and Cromwell, their case was, it was gross in a predictable way if you've been following these issues. So they're using a their whole case is based on a definition of gender identity, which is paradoxical. They've got these expert witnesses on the stand, not really citing scientific studies, but instead just being like, oh, I had a friend who saw this, or I don't see any side effects in my patients, just like, playing really fast and loose with everything and not having a lot of science to draw on that you'd expect from expert witnesses. You also had contradictions in their case. They have one expert witness, Dan Karasich, who you might know from the WPATH files. He's a psychiatrist in California. He gets on the stand and tries to make it sound like clinicians in the field are all doing this really thorough job of assessing kids, and they're sending them to mental health assessments, and they're making sure that the gender dysphoria is very long-standing, although he won't specify what that means. He's trying to paint this picture that's all very conservative. And then you get the parents on the stand talking about their kids, and you realize like 2 of these 4 kids were definitely ROGD. And I personally don't think that any kids should be trans, whether they're just so-called dysphoria came on recently or a long time ago. But it is, a big point of contention in the gender doctor world, and the plaintiffs themselves are trying to make it sound like, oh, the gender dysphoria has to be longstanding. But then you could see just a couple of days later, in terms of people testifying, that it wasn't true on the ground, that they just kind of, Dan Harris is just making that up. You also heard that from some of the doctors who testified, who were just practitioners in Arkansas. So, these people are contradicting each other left and right. They don't have any statistics to back up, for example, their claim that kids will commit suicide. The way they get around the suicide thing, I think if you're listening to this, you've probably heard the myth that kids will kill themselves if they can't access gender medicine, but there's no studies whatsoever or no reliable studies that is based on. So the ACLU, instead of doing what like ethical lawyers would do and say, well, we can't make that point, there's no evidence for it, they just have all their doctors sit in the stand and kind of darkly insinuate that kids will kill themselves. And they say, like, I'm afraid kids will kill themselves. And this is all like, this is not what expert witness or any kind of witnesses are supposed to be saying on the stand. But they said it. Arkansas did not object or point out in their briefs the issue, and the judge bought it too. And the judge kind of quoted the experts saying these things that were not based in evidence.
You say it's 1%, but what else is wrong?
Oh, you have expert witnesses testifying about subjects that are clearly not within their expertise. So, for example, you have the endocrinologist just talking about how great her treatments are for the kids' mental health, and she's also talking about like the girls' mastectomies and how they still have nipple sensation after the surgery, or like they don't complain about lack of nipple sensation after the surgery. And it's just like, what? You're an endocrinologist and you're treating like hundreds and hundreds of people a year, and you're having these discussions about nipple sensation with these kids who another doctor just told us are not sexually active in this population. You had Jack Turbin also talking about mastectomies. He's a psychiatrist and he's talking about surgery. So they're just like way wandering all over the place, testifying to whatever they feel like. Arkansas might have objected a little, but generally not to what I just described about testifying outside their competency. And the judge just counted all of it. Like, he would quote them, and he said that they were experts, and literally, and this is like almost a quote, like everything they testified about, they were an expert in. And this is not normal.
And as I recall, you had called out Arkansas for choosing ineffective arguments. Can you speak to that a little bit?
Yeah, so they did not. They first of all just didn't hit all the arguments they could have. There were things where they just weren't raising objections when they could have, or they weren't challenging certain concepts like gender identity. When I first read the transcripts, I thought, well, they're really outgunned, and I guess they didn't have time to prep every possible argument. I don't know if that's accurate in terms of judging what was going on, but like that's one possibility. And they kind of accepted the premises of gender medicine. So, for example, at the end of the trial, when they submit their brief to the judge that lays out their proposed finding of facts, like what they want the judge to find to be a fact, they say the term gender is commonly used to refer to one's internal perception of their sex. One's gender identity may be male, female, or non-binary. That is, neither male nor female, or both male and female, or fall outside those 3 categories. That's like, that's not what a good gender critical person says. And it really, it's really kind of agreeing to fight this on the terms of the other side. when in fact, like the other side has built their entire case on something that is nonsense, gender identity. And I wrote a post kind of laying out exactly how gender identity, as they presented it, is paradoxical. And this is, remember, step one of their case is just showing like what the problem is that has to be treated. It's the incongruent gender identity. And Arkansas kind of stipulated to that. And to be fair to Arkansas, there are reasons why you might narrow the case in this way. And one of them is kind of evident from this paragraph. They're citing as experts the plaintiff's experts, okay, but also some of their own expert witnesses were doctors who bought into this paradigm. So the big one is Stephen Levine. He's a gender shrink out of Ohio who's been doing this for many decades. And he's somebody he's critical of the affirmation model, the affirmative model. He doesn't think that kids should be trans at age 2. But he does believe in transitioning people, including teenagers sometimes. So this could represent the fact that it is very hard to find expert witnesses for these cases. People who not only have these beliefs, the gender critical beliefs, but are willing to state them on the record and are willing to go through all of the kind of hassle and harassment that goes along with being an expert witness. So, it's possible that Arkansas was in a position where they just they couldn't put together a case based on testimony that we would believe to be like more rational. Maybe that was going on. So I want to open up that possibility.
And they could have, for example, identified gay and lesbian kids as the primary recipient of this form of quote unquote care, and they did not press that point.
Correct. So there's something very interesting going on in this trial where both sides just erase gay people. Like, gay people are not characters in this, even though the ACLU refers to this as an LGBTQ case. And even though we know, as people who follow this field, that gay people are the victims of this. So the state is the one that should have been putting gay people front and center, and they did not. There were arguments that they just let the ACLU get away with. So, the ACLU and their expert witnesses are saying that it's conversion therapy if you quote unquote try to change somebody's gender identity. Conversion therapy is a concept from the gay rights world or the gay psychology world, because you can't change a person's sexual orientation because that's based in biology. So the trans side, as you're probably familiar with, they run with that a lot of times and they just do a find replace, and they say that's also true of gender identity, but it's not. They don't have the scientific basis for saying that. The state did not attack that. Our ACLU also was careful to distinguish gender identity or trans identity from gender nonconformity, but they really were not convincing on that point. And, they would just say like, oh, if a girl is a tomboy, she likes playing the same games as a boy, and it says that she likes boy clothes, that's not the same as her saying she is a boy. I'm like, what, really? Are you sure? Like there are so many ways you could poke holes in that, and the state did not. The state just let that stand. And when we're talking about gender nonconformity in kids, a lot of times that's the precursor to being a gay adult. So again, the ACLU is just in this very glib way. They just say these two things are not the same: gender nonconformity and childhood and trans identity, and that stood as a fact because the state didn't attack that, and they definitely did not point out the correlation between trans identity and gay identity. Minority stress is something that the expert witnesses on the plaintiff's side really milked, saying that any kind of mental illness that was found in trans people was due to minority stress, was due to the persecution they face as trans people, and not, for example, a comorbidity that should be explored in therapy. So again, that's something where the evidence base is for gay people, not for trans people, but the state did not attack that and make that point. When it came to putting witnesses on the stand, the state did put detransitioners there, which is good, but they somehow found the two detransitioners they used as witnesses were fine people, but they were both so hardcore Christians. They seem to have been it seems like Arkansas found them through Christian circles. And so their story of detransition, and they were both heterosexual, apparently. They were both married to people of the opposite sex. So it was kind of an idiosyncratic story they're telling about having these religious inspirations for detransitioning. And in my book, that's fine. That's a fine reason to detransition. But the plaintiffs and the judge jumped all over that and said, oh, it's all about religion for them. And of course, we know that a lot of detransitioners are gay, and that's because gay people are targeted and harmed by gender medicine. And considering that they had a liberal judge on the stand, this Obama appointee who went very hard in favor of the ACLU in the end, it seems like the strategy would be kind of obvious to the state that they should put gay transgenders on the stand and they should emphasize all the ways that gay people are harmed. It seemed like that this judge would have gone for that. Plus, it would be truthful to what's going on. So that it's a really grave omission. You had to wonder about it.
So just to sort of underline how ineffective this case was, they go to appeal, is my understanding, and you've looked into this appeal. And why don't you talk about that?
Yeah. So again, this decision from the trial comes down last June, and Arkansas moves to appeal. So that's good. And this goes to the Eighth Circuit Court of Appeal. We're talking about federal courts here. So, and that was briefed over the fall and winter. About a couple of months ago, it went up for oral argument before the full panel of the Eighth Circuit. So it's called en banc review, and this means that the entire Eighth Circuit is something like 10 or 11 judges heard it, and it's the last step before the Supreme Court. So they had oral argument, like I said, a few months ago, and it was a very narrow oral argument in terms of the state did not. So the state lost, so they were the ones bringing the appeal. And they just did not challenge a lot of what happened, almost anything that happened at the trial level, even though there were a lot of problems with the way the ACLU made their case and with the way the judge issued his decision. One thing that I just love, it always jumps out at me, is that the judge, he just wrote off the state's case. Like all their expert witnesses, they had doctors on the stand and everything. The judge just wrote it off by saying that they were all testifying based on their religious beliefs and not based on science. And this was just like, he didn't have any basis for saying that. I mean, in a few cases, the ACLU did kind of hammer on the witnesses, like, you're Catholic, aren't you? But like, that didn't obviate the science that was being presented by these experts. And for some of the experts, their religion was not brought up at all. The obvious example being Stephen Levine, that sexologist who's been this doctor for trans people since the 70s. Like, this guy doesn't come off as a hardcore Christian. And in fact, there was nothing about that on the trial record. And yet the judge claimed that he was testifying only based on his religion. And then even weirder than that, the judge, like, instead of throwing out all of his testimony, he actually kept some of the lines that seemed to like sort of support the ACLU's case. So it was like, so the judge was just clearly cherry picking what he wanted and saying that was somehow reliable and valid and not based on religion. But the other stuff the guy said was based on religion, even though we didn't even know what his religion was. So like total wackiness. And Arkansas did not press back on that at all. They didn't raise it. At one point, a judge on the appellate panel actually asked in a sort of incredulous tone, like, wait, so you're not challenging any of the facts, are you? And the lawyer for the state said, no, they're just, there's this one particular legal point that they're hanging their whole case on, which was an important legal point, but certainly not everything. And that was it. So I mean, listening to that, I'm very reluctant to kind of criticize the strategy because I'm not privy to their conversations, and there could be things I'm not thinking of. They're working sort of in concert or with some coordination, I believe, with other states. So maybe for some reason they decided to go easy on this one. But it's, as an observer, it was disappointing. And, good litigation is not only about impressing some, random people out listening on their couch at home, for sure. So that's why I hesitate to be too critical, but it was kind of an eerie feeling listening to the arguments. Like, it also just didn't seem very energetic. Again, it's my totally subjective impression, and who knows? But considering all the passion that people like you and me have at home following this issue, it was just surprising to listen to an argument in this in a federal appeals court, a very exciting venue, and it's just kind of, yeah, we're not challenging this, we're not challenging that. We just have this narrow legal argument to make.
So kind of phoned it in a little bit is what we're getting at, I guess.
That was the vibe. And again, like it was competent in a way, but like I feel I really don't like criticizing a lawyer when I just don't like I feel very, yeah, I feel like this is very bad karma to just be like sitting around anonymously criticizing these lawyers. But man, I do not know what's going on.
You've also followed this case in Alabama. So let's talk about Alabama, which has been quite a different case. And I'll just say, for full disclosure, that Steve Marshall, I've been on the opposite side of Steve Marshall a little bit, and I admire his steel trap mind. He seems to be much smarter than the AG of Arkansas, anyway. Tell us your impression.
Sure. So Alabama is the second state in the United States to pass a ban on pediatric gender medicine about a year after Arkansas did. And again, some lawyers swoop in and file a lawsuit related to that. But what we're talking about in Alabama is it kind of a similar lawsuit in terms of how it's structured, but there's a lot of drama between that is going on alongside this lawsuit. And so and some of it broke out into the open, and we were able to research it and read about it a couple of months ago. So this is a fun case in terms of what it showed us about the behind the scenes machinations of the plaintiff's lawyers.
Oh, that sounds interesting. Go ahead.
Sure. So uh, there were actually, so the ACLU was involved in Alabama as well. They were kind of organizing the same way they were organizing down in Arkansas, and they had co-counsel who was like a major law firm. They were also working with Lambda Legal, which is the other giant of the LGBT law space. So they're down there in Alabama preparing to file their case as soon as the law is passed. But they're not alone. There's another set of lawyers who are also doing the same thing they are. And they are from a bunch of different organizations, including the Human Rights Campaign and GLAAD, National Center for Lesbian Rights. And they have their own big law firm that they're co-counseling with. And they're kind of in competition, apparently. These two bunches of attorneys. In total, there are 39 lawyers for 11 different organizations and law firms, all down in Alabama, not a huge state, all wanting to file the same exact lawsuit, which is kind of a similar lawsuit to the one they filed in Arkansas, where I don't know if I mentioned this, but they're not only representing the so-called trans kids and parents, they also represent the doctors for the kids. So they're like literally representing the interests of doctors who are trying to make money off of this thing. So that's like their team. And
That seems a bit conflictual of interests almost.
that yep, they're arguing the opposite. The doctors have the kids' interests in mind. Whatever. I think it's cool. Just say that quiet part out loud. But anyway, so they're both putting together these cases, and then they both race to the courthouse once the law is passed and signed into law. But they are they can do, so they're both seeking, they both have like a few individual plaintiffs, like people like kids and the parents and everything, but they are seeking for these to be class actions. So they have different individual people who they're showcasing, but they're both aiming to represent all the trans kids in the state. That's the end game there. Once the lawsuit gets underway, they're going to see class certification. So then they would be like the same lawsuit. So they both file, and they both have this terror of being assigned. They're very concerned about which judge their case is assigned to, and they don't want it to be assigned to this guy, Lyle Burke, who is a Trump appointee who has a reputation for being very conservative. There's a rumor that he had a portrait of Jefferson Davis on his wall in his old office. So they both have this anxiety about being in front of that judge. And so just in general, for background, the federal courts, they generally assign cases to judges in a random way because, the theory is all judges are the same, but we don't want anyone trying to game the system based on like some sleazy reason. We want a system that seems very fair. And so you can't angle to get a certain judge. It's all done randomly. With the exception being if your case that you're filing is related to a previous case that's already in front of the judge, then, just for reason of efficiency, then they'll put it with that same judge. But generally, you're supposed to have randomly assigned cases. So, so these two teams engaged in some shenanigans because they were, in particular, and one of the teams is worse, and it's the ACLU team, ACLU, Lambda, and their big law attorneys. They are totally desperate to avoid Burke, and they have this particular judge who they want to get assigned to, just because he, like a couple of years ago, he issued a ruling that favored a trans identified person. So they're like scheming to get their judge put in front of that guy's face. Of course, there's no like legal or ethical way to do this. So they pretend that it's related to that previous case that was filed. And at the same time, they're like calling up the chambers of that judge and like talking to his clerks just to be like, hey, just so you know, we're filing this emergency motion on this case we just filed, which is related to a previous case of yours. And it seems like they're trying to kind of put it on this judge's radar, which goes nowhere in terms of getting it assigned to that guy. They are calling and texting their like friends and friends of friends who have clerked in the federal system in Alabama to like ask them advice for how to get their case assigned to the right judge. And like they get a response from one person who's like, they're assigned randomly. Like, we're like, leave me alone. This is weird. In terms of, at least in terms of us finding out about these machinations, this is weird stuff. Like, it's not something you hear about every day. Um, and I'm gonna skip over some of you just trust me, there's a lot of back and forth with them like trying to get their case in front of a certain person. It ends up in front of Judge Burke, as does the other team's case. They get kind of consolidated because remember, everyone can see they're going to turn into the same lawsuit. So they both end up in front of Judge Burke despite their best efforts. They have a panic attack because they believe that the assignment wasn't random. Like it seems like they believe actually that Burke found out about their case and wanted it for himself. And the word they use is snagged. Like he reached out and snagged it was what they thought. And just my guess is no, that did not happen. Like that is really weird. And I don't think conservatives particularly want to handle these cases as much as the ACLU's paranoid visions suspect that they would.
Basically, what they're doing is judge shopping. So they end up in front of Judge Burke anyway. And what happens then?
So at this point, the two teams remember, like they're both in front of Judge Burke and they talk to each other and they decide like this cannot go forward. Like we're definitely going to lose if it's in front of Judge Burke. What are we going to do? They decide they're going to both dismiss their cases and then they're going to file a fresh new case. And with a whole new set of tricks on they're going to file their new case in a different district of Alabama. Like there's different so-called districts within the state. So they think they're going to file in a different district so that they can avoid Burke. I think he's in the northern district and they're going to file in the middle district. So they agree to dismiss their cases, all of them, both their cases. But one of the lawyers on one of the teams talks to the media because these guys are, they're always in touch with the media. And they say, and instead of just like being cool about it, and I don't know, maybe not talking to reporters for a couple of days, they say to the reporter who asked the question, "Oh, don't worry, we plan to refile immediately." Is what? That's like, well, why are you dismissing a case in order to refile it immediately? So eventually, the judge, the scary Judge Burke, sees this line and he's like, "That's really sketchy." And this might be in combination with other things he observed. I'm not sure, but he winds up referring it to kind of an ethics panel of judges, federal judges within Alabama, and says like, please investigate this. There's some things that don't seem right. Like why are these people dismissing their own lawsuit with the plan to refile it? And at the same time, so these lawyers do refile. It's the non-ACLU team that files the new case. So it's people from NCLR and HRC. They file their brand new lawsuit with a different name plaintiff, but it's still with the goal of having a sort of class action. They file that in a different district, and the court system says, "Oh, this is related to that previous case you filed a couple of days ago." Because remember that is a rule that the related case to get sent to the same judge. So they say, even though this is in a different district, it's related to the first case, we're sending it back to Judge Burke. So all their shenanigans were for nothing. It was a total waste of time. And worse than that, it got them in some big trouble. So the reason why I know this whole twisted story is because that ethics panel, they did investigate. They did a deep investigation. They talked to many of the lawyers involved under oath. They had them submit affidavits, they held hearings, and I think we're still back in 2022 now. So really deep investigation that goes on, and then they produce a report. The report, they issue it last fall, but it was under seal until like I think March of this year. And they just lay out in excruciating detail all these dumb little ploys that the lawyers engaged in. But on top of the shenanigans, the lawyers, it turns out, like really hate each other. Remember, there are these two teams, and it's who are all clustering around this one lawsuit. They hate each other. So it was very interesting for me to read, because I've been I've been studying these lawyers, because some of them have been practicing since the 90s in the same area of LGBT rights. And honestly, it's really funny. They're like kind of putting each other down in front of the judges who are kind of evaluating whether they broke any rules or laws. They're talking about like these phone calls they had that just devolve into screaming matches. So it's just like total pandemonium.
What you're describing makes me think of a scene in Attack of the Killer Tomatoes, where all of the experts are stuffed in a tiny little room with a great big table. And so they have to climb over the table and over each other to get into the chairs. So basically, there are too many people, and they're all kind of taking each other on. They're all sort of they're playing a game of Mean Girls at the same time they're trying to win this lawsuit. And what it all comes down to is they've convinced themselves en masse that this one judge is definitely not on their side. There are a couple of anecdotes here that I thought were kind of entertaining. The lawyer who called the chambers of Judge Thompson was Carl Charles of Lambda Legal, who is apparently transgender, I guess. The text that you have here recorded is, but shortly before the panel read her cell phone number to her, Charles asked if she could correct her earlier answers and admitted that she did call Judge Thompson's chambers.
Yeah. Oh my gosh. So the story of Carl Charles. So Carl Charles is somebody who is apparently like one of the relatively low-ranking people. Like I think this person is kind of young, a few years out of law school, working for Lambda Legal. And in part of the flurry of activity of making all these phone calls and trying to finagle the case onto Judge Thompson's docket, they ask her to call the judge's chambers, so call like the people who work for the judge, and alert the judge to the fact that they filed this case under the pretext that it's related to his previous case. It'll be assigned to him, and they're going to be coming to court soon to file their emergency motion to stop the law. So that's like the pretext. That doesn't make sense, because the case is not related to that previous case, and it's not going to be assigned to Judge Thompson. In fact, it had already been assigned to a different judge at that point. But so Charles has the job of making this phone call to judges' chambers, and apparently does that, and then is asked about it by the judges many months later when they're investigating what happened, what the play-by-play was. And they ask her in 12 different ways, like whether she made this phone call to the judge, and she's saying no. And then it's kind of drawn out. At one point, she pauses for a long time, and then she comes back and she says, "Oh, excuse me, I'm only pausing because what does she say? Like, I'm thinking really hard to make sure I get it right." There's some funny language like that. Very earnest. But in front of these judges, the panel of judges later, after denying making this phone call 100 times, they like read out her cell phone number because of course they have the phone records. And then it's like, "Oh yeah, no, I do remember. Sorry, it was just a really busy day." And so now that person is being well, they haven't determined whether there'll be sanctions of her and other lawyers, but she is facing harsher charges than the others because it's potential perjury because of this sequence of events.
And perjury is sort of frowned upon with officers of the court, I understand.
Oh, a little bit. Yeah, I think they mentioned something about that in law school. But for all of that kind of shame that you would expect from facing perjury charges, Carl Charles is right now doing okay. Carl Charles moved from Lambda to the Department of Justice, the U.S. Department of Justice. So last we heard, that's where she was working for us, the people.
So teaching the Biden administration to do judge shopping. How wonderful.
Mhm.
So there was also another name that came up. We'll go with one other name, but this name, because the potential offenders, were interviewed in three different groups, and it's only the people who we were just talking about, Carl Charles, stands to be one of those people who might be punished. That hasn't been determined yet. But in the group that, is seen as having input and responsibility, but likely not to be punished, there is one famous name. Maybe we should headline that. Maybe it should be Chase Strangio implicated in judge shopping scandal. What do you think?
Well, unfortunately, Chase Strangio is not facing sanctions because she wasn't important enough, is what the judges decided. But I want to make James Essex a household name. Actually, I understand why we all get a little bit annoyed with Chase Strangio. That is the poster boy, as they would say, poster BOI of the ACLU trans movement. But James Essex, Chase's elder colleague, has been litigating these cases since at least 2005, these trans cases. And this is a guy who, I mean, what I like about James Essex is that he totally knows that this is a lie. Like in his lawsuit that was filed 2005, one of the big points of contention was whether there's a biological basis for gender identity or for trans identity. The answer is no, there's not. And I won't go off into that whole tangent. I've written about it, but it was very clear from that record that he and everybody working on that case knew by the end of it, oh, there is nothing there. There is no biological basis. And yet James Essex, for the past 20 years, just keeps coming back to court and saying there's a medical consensus that gender identity is rooted in biology.
Yes, it goes down in the annals of legal fiction. Should probably be such a publication. The Annals of Legal Fiction. So you had said actually that the Eighth Circuit might eventually rule for Arkansas anyway. Like that might not matter how they argued the case. We have to point out that there's at least some amount of doubt about where any of these lawsuits are going, and we're, of course, as you say, not privy to insider information. Since we have judge shopping in one state, do you suppose that maybe Judge Moody got shopped in Arkansas? Like, is that just a possibility in your mind? You might not have any evidence to suggest that, other than a gut feeling. Just a gut feeling. What do you think?
I would never, ever speculate without evidence, without a firm report signed by 3 judges, that a certain group of lawyers is going around judge shopping in the South. So I just cannot make any speculation whatsoever about how those lawyers who were the same people in Arkansas a year earlier ended up with a super favorable judge. I just can't say.
That is a perfect answer. Returning to Alabama, it's my understanding that Judge Burke, did the thing that Leor Sapir had warned everybody you have to be prepared for. We're always going to lose the initial motion to put the law on hold. And basically, that's something that is considered pretty normal in a federal courtroom, particularly the 11th Circuit, because they're used to dealing with Alabama and abortion laws. Like every year, Alabama passes, hey, what creative abortion law have we not thought up before? Let's pass it. Just to make a case in the 11th Circuit that we can get it overturned. It happens every year. Tell us
Yeah.
about the preliminary motion injunction.
Yeah, so what that is as soon as the lawsuit's filed, the plaintiffs come forward, and this is in every state, and they say, it's an emergency, and while this case is pending, it's going to be pending for like a couple of years. During that time, we got to make sure the law does not go into effect. We need an injunction that will be temporary for the duration of the lawsuit. And so the team did that here. And by the way, so the ACLU is not representing the parties now in Alabama, because remember, it was the other team that wound up filing this lawsuit ultimately. So bunch of acronyms there, HRC people. So they're lawyers and they bring that motion. They actually win in front of Judge Burke, even though they were so terrified of him. But then the state appeals, and then the appeals court flips Judge Burke. So right now, the law was able to go into effect, and this is true in much of the country. So I understand why there was reason for pessimism in terms of how the preliminary injunction motions would go. But there were some appeals courts that saw things the right way. There were some trial courts as well, at least one in Missouri, where the plaintiffs did not get their preliminary injunction.
So basically, they had, done this judge shopping scandal in order to avoid a judge who decided for them anyway.
Yes, and then they lost anyway at appeal.
And in appeal, this is my understanding, is that the state attorney general, Steve Marshall, had was getting disclosure, or what we call discovery, I guess, from WPATH as a result of the AAP and the Endocrine Society both saying, it's a circular citation scheme. So both of
Well,
them
yeah, I think
sort
what's
of
going on
bowed out of
is,
this.
yeah, I think that once a lawsuit proceeded, I believe that Alabama Attorney General's office, in defending it, said that they needed information from WPATH because this was going to become relevant to the lawsuit. Because I think they were saying that the plaintiffs were going to argue that their plan to trans kids was totally scientific because it came from WPATH. So then the question is, well, like, did WPATH come up with this plan in a scientific way? We got to find out. We need discovery from WPATH. I think that's what happened.
Yes. So the two other organizations ended up bowing out of this affair, and the focus came down to WPATH. So he, by some point last year, would have had documents from WPATH, or would have received information from WPATH. Possibly, the same files that we've seen in the WPATH files, probably he got some of that. So let's imagine he has this information from within WPATH. Let's put yourself in his place. What are you doing with that information from the WPATH files if you are in his shoes in that 11th Circuit courtroom?
Oh, so this would be yeah, we're not in the circuit courtroom now. I think this is the investigation that the Attorney General's office is doing. So they are, I believe there was some fighting over those documents, but the trial judge ultimately decided that they were entitled to get the documents from WPATH. So that is part of their case now. I believe they're still in discovery, so they're probably taking depositions and things like that. The trial is scheduled several months out, maybe later. But they are trying to, and I don't think they would have gotten the same documents that we saw in the WPATH files. Um, maybe if they just got like a huge dump of everything in WPATH records, but what they might have gotten is like surprisingly little, like because they're asking about what kind of scientific deliberations went into things, and they might have gotten like some blank pages back.
That would actually be very interesting. You're right. But more to the point, if you had the WPATH files and you were in his position, like, what would you do? How would you attack that case, do you think?
Well, typically the way that the plaintiffs pursue these cases, like you saw in Arkansas, is that they have at least one expert witness get on the stand. It was Dan Karasich in Arkansas, and they testify to how awesome WPATH is and how the WPATH guidelines are followed by clinicians. And because clinicians are following those guidelines, which are so awesome, that means that it's all very scientific and medically necessary and blah, blah, blah. So now a lot of the big players at WPATH, including Karasik, have been really discredited because we've seen these really embarrassing videos of them and so on. So anytime, I'm not familiar with how many of the WPATH characters were kind of shamed by that, but it was a bunch of them, right? Like they're all saying dumb things on message
Oh, yeah.
boards and in training sessions,
Yeah.
and
And,
yeah.
and prominent ones, not just, nobodies, but the prominent folks in the
Yeah,
organization.
exactly the people who you'd want to use as your expert witness. They're now tarnished, and so they will have to answer very embarrassing questions. The judge will find out that they were saying things like, "Oh, here's how you get consent from somebody who has 9 different personalities." They're saying things like these kids can't possibly consent because they don't really know what they're giving up in terms of fertility and a sex life. So that will all be wide open. The Attorney General's office will be asking questions about that of any expert witness from WPATH, and they'll look bad.
So, in other words, there is potential that the Arkansas case may not matter and the Alabama case could matter much more. We don't know the
Well,
future, but
I
that's
mean, when we talk about mattering, it's about which ones get taken up by the Supreme Court. So, we, so this is, so remember, Arkansas is way out ahead of all the other states. There's like 25 states that have passed bans now, and maybe like a majority of them have lawsuits pending. So Arkansas was first out of the gates. They've already had oral argument at the Court of Appeals, so they are far along. Either side, if they lose, could appeal to the Supreme Court. And I'm hoping the Supreme Court would not take it at this point. Like they would want to see more of the cases bubble up, and have there be sort of a conflict between different states or different circuits. They call it a circuit split. I'm hoping that the Supreme Court would not want to take up Arkansas. And the reason is that Arkansas has a poor record. So what I mean is, like, a strong record is one where the state made a lot of objections and they made a lot of strong arguments and they put on witnesses with really compelling testimony and they preserved the record through appeal and everything. Arkansas is not that. Arkansas is very weak. The state did not make all the arguments they could have made. They did not object to everything they should have objected to. When you're at the Supreme Court, you can't be arguing that, oh, that endocrinologist should not have been testifying about mental health. You can't really make that argument if you've never made it before in the trial court. So if the Supreme Court took up Arkansas and no other cases, then that would be bad for our side. I don't think they will. I think they'll want to see more cases bubble up, but it is a risk because Arkansas is out front.
and it's a good thing that Alabama is right behind. So now that we have worked our way through these two cases, let's have just a minute for you to talk about yourself. I mean, you do some terrific work, and you kind of can't tell us exactly what you do for understandable reasons. A lot of us have to be that way still. So just tell us about yourself a little bit and tell us about your Substack.
Yeah. So like I said, I'm a lawyer. I work in, we'll call it the public interest field. So it's kind of a broad way of saying, like, I've worked in places that are either government or nonprofits. The causes I work for are things on the left. I've always been, if you look at me on paper, I've always been solidly on the left. So I'm now very angry to find myself here with everybody around me being like so wrong. Although I shouldn't say everyone around me, because of course I have found a lot of individuals in my circles who agree or are very open to hearing more about trans. But I'm in this awkward space where my whole career has been on the left as a lefty lawyer, and now I'm just watching these lefty lawyers of the ACLU just make these arguments that I consider to be really despicable. So I started writing. When I first got on Substack, I was actually writing for Lisa Salon Davis's her great Substack. I know her, or I was introduced to her by mutual friends. So some of my earlier pieces are with her, including like these 12 posts about the Arkansas lawsuit, Brent v. Rutledge. So when I started writing about that end of last summer, and then I was like totally hooked on trans stuff. I mean, I've been following it for a while and getting more pulled in, but this was like, I mean, it was just so fascinating for me to read the trial transcripts and see exactly how the arguments were being made by the ACLU and Sullivan and Cromwell. And it made me think like, oh, I want to stay here. Like, I want to keep on dissecting this. I want to just play my small part in trying to expose this to more people. In general, I believe that it's good to try to translate legal concepts into plain English. It's good for everyone to understand what's going on in the courts. And in this situation in particular, oh my God, like just looking at how shallow and superficial the media coverage of this case was, and then to just open up the actual filings and the transcript myself and see what a gulf there was in terms of, the media coverage versus the reality. It was very exciting. And so that lured me into this whole practice of talking about trans on the internet. After I wrapped up that series on Lisa's, it was mostly on Lisa's Substack. It was posted in a few places. After that, I think it was November, I started my own Substack, which was originally going to be about legal history, like the kind of history of the lawsuits of the trans movement. But I kind of migrated out into the general history because nobody was stopping me. And it's been super fun and disturbing and like kind of an emotional roller coaster because I'm just so upset by all this stuff that I'm reading. But I'm glad that you've been reading and you've been cross-posting for us, for me. And it's just, I've been very excited to see it kind of get out there a little bit and be able to talk to more and more people about what I'm reading.
Yes, you have done some really terrific historical work, I must say. And that's been kind of a joy to me as a historian because I'm not a lawyer. I tried mock trials in undergrad and I said, no, I don't want to be a lawyer. And so you do this great service to me of going through the sort of legal history of these precedents. And you were referring to Mr. Essex before, whose name has a K, it's not an X. And Mr. Essex apparently coming up with this bizarre way of arguing out of thin air. And it's all very entertaining and interesting. So I highly recommend it to readers. And I do try to amplify it as much as possible because you do terrific work.
Just keep following these lawsuits. I will be doing my best to analyze what I can and put it out there. I think it's so important for everybody to understand what is going on in the courts and to understand that places like the ACLU and unfortunately the Department of Justice under Biden, they are not doing honorable work anymore. I know that for us on the left, it's disturbing and sad, but it's true. You cannot respect these institutions just because they have high status and they hire people from good schools and they used to do good work. Unfortunately, they are being scoundrels lately.